On the evening of August 20th, 2015, Edward Caniglia and his wife Kim had an argument inside their home in Cranston, Rhode Island. It was the kind of argument that happens in a lot of long marriages. The Caniglias had been together since 1993, and it might never have gone further than a bad night, except for what Caniglia did in the middle of it. He walked into the bedroom, came back with a handgun, set it down on the dining room table, and told his wife something to the effect of, "Shoot me now and get it over with." The gun wasn't loaded. Caniglia knew that. Kim did not. She took the gun and its magazine and hid them, and Caniglia left the house to drive around alone for a while. When he came back, the argument hadn't cooled off, and Kim decided she'd rather spend the night at a hotel than stay in the house with the tension still hanging over both of them. Neither of them called the police that night. Neither of them thought they needed to. It was, by every account either of them would later give, a bad argument between two people who had been married for more than 20 years, not the kind of night either of them expected to end up described in a Supreme Court opinion. The next morning, Kim couldn't reach her husband by phone. She started to worry. Not that he'd done anything to her, but that he might have hurt himself, alone, in a house she hadn't gone back to. So she called the Cranston Police Department's non-emergency line and asked for a wellness check and for an officer to escort her back to the house so she wouldn't have to go in alone if something was wrong. That single phone call is where this case begins. 6 years later, it would end with a unanimous United States Supreme Court, all 9 justices, ruling that what happened next inside that house should never have happened without a warrant. Kim Caniglia made that call to get help for her husband, not to start a legal process that would eventually reach the country's highest court. That gap, between why a call gets made and what a call sets in motion, sits at the center of almost every case this channel covers, but rarely as starkly as it does here. Officers reached Caniglia by phone that morning, and he agreed to talk with them in person. No resistance, no standoff, nothing that looked like a crisis in progress by the time police arrived. When they got there, Caniglia corroborated his wife's account of the argument. He told them he'd brought the gun out because he was tired of the fighting. He denied being suicidal. There was no criminal charge on the table. There never would be one. Caniglia had no arrest record, no restraining order against him, nothing in his history suggesting violence or a misuse of firearms, a fact that would later go undisputed in every court filing on either side of the case. He was, by that morning, a 68-year-old man standing in his own driveway, answering questions calmly about an argument that had already ended the night before. The senior officer on scene, Sergeant Brendan Barth, wasn't convinced. He decided Caniglia should be evaluated at a hospital. According to Caniglia's own account, he agreed to go only after officers assured him his firearms would not be confiscated while he was gone, an assurance that, within a matter of hours, would turn out not to hold. He was taken by ambulance to Kent Hospital, evaluated, and released the same day. He was never admitted. Whatever the hospital's evaluation found, it wasn't enough to justify holding him. By that afternoon, Edward Caniglia was a free man who had cooperated fully with every request made of him, cleared by the very medical process police had insisted on. He had done, in other words, exactly what was asked of him at every step, agreed to talk, agreed to go to the hospital, submitted to an evaluation he could have contested. And none of that cooperation stopped what happened to his house while he was gone. While Caniglia was at the hospital, not under arrest, not facing any charge, simply cooperating with a wellness check that had already run its course, police entered his home. They did not have a warrant. They did not have his consent. He wasn't there to give or withhold it. According to the police, Caniglia's wife directed them to where the firearms were kept. Whether she actually wanted the guns removed or was simply answering officers' questions about where they were became one of the disputed points in the case that followed. What isn't disputed is what happened next. Officers seized both of Caniglia's lawfully owned handguns, along with their magazines and ammunition, and left. When Caniglia and his wife later tried to get the guns back, the department told them no, not because of any ongoing investigation, not because of any new concern. Because, they were told, department policy required a court order before property seized for safekeeping could be returned. A man with no criminal charge against him, who had voluntarily gone to a hospital and been released the same day, now needed to go to court to get his own legally owned property back from the police department that had taken it while he wasn't home. The irony of that requirement wasn't lost on the district court either. While it sided with police on the community caretaking question, it separately found that forcing Caniglia through a court process just to reclaim property that was never connected to any crime violated his due process rights. Even the court that ruled against him on the central Fourth Amendment question couldn't defend the return policy on its own terms. It took more than 3 months. The guns weren't returned until December 2015, and only after Caniglia's attorney formally intervened. Shortly after that, Caniglia filed suit against the city of Cranston, the police department, and the individual officers and officials involved: Sergeant Barth, Captain Russell Henry, who had approved the seizure, officers John Mastrati, Wayne Russell, and Austin Smith, and Police Chief Michael Winquist, who had personally denied the request to return the weapons. The lawsuit alleged violations of Caniglia's Fourth Amendment and Second Amendment rights, along with state due process claims. He was represented by Thomas W. Lyons III and Rhiannon S. Huffman, cooperating attorneys with the ACLU of Rhode Island. The legal theory the police relied on to justify entering Caniglia's home without a warrant had a name: the community caretaking exception. It's a doctrine that traces back to a 1973 Supreme Court case called Cady v. Dombrowski, and in that case, it applied to something narrow and specific: a car. An off-duty police officer in Wisconsin had been in an accident, and his own department had his vehicle towed. Assuming, correctly, that officers commonly carried service revolvers, someone searched the trunk to secure the weapon before the car sat unattended in an impound lot. The Supreme Court held that this kind of search, performed for reasons entirely separate from investigating a crime, didn't require a warrant, because a car sitting on a public road or in police custody carries a much lower expectation of privacy than a home. The court's language in that case leaned heavily on exactly that distinction. Cars are mobile, heavily regulated, and routinely subject to police contact in ways homes simply aren't. The question at the center of Caniglia's case 5 decades later was whether that same reasoning, built entirely around a vehicle in 1973 under a very different set of facts, could be stretched to cover the inside of someone's house. Nothing about the original 1973 ruling had anything to do with homes. Nothing in it suggested the court intended the doctrine to travel that far. But lower courts across the country had, in the years since, begun applying community caretaking more broadly, and Rhode Island's federal courts were among those willing to extend it into a house. The U.S. District Court for Rhode Island said it could. The court sided largely with the police, holding that the community caretaking exception could reasonably be understood to extend to homes, and granted the officers qualified immunity on that basis, a legal doctrine, separate from the underlying constitutional question, that shields government officials from personal liability unless they violated a right that was already clearly established at the time they acted. Because no prior ruling had specifically said community caretaking couldn't apply to a home, the officers in Caniglia's case were protected from being personally sued over the decision, regardless of how the broader constitutional question eventually turned out. The First Circuit Court of Appeals affirmed that ruling in March 2020, reasoning that police community caretaking functions could extend beyond vehicles and into private homes. That decision meant that as of early 2020, in Rhode Island and the new other states covered by the First Circuit, a wellness check with no active emergency and no criminal charge could, in theory, be treated as sufficient grounds for police to enter a home and remove property without ever going in front of a judge first. It was a ruling that quietly expanded police authority over private homes across an entire region of the country, built on a single sentence of reasoning borrowed from a case about a wrecked car in Wisconsin nearly 50 years earlier. And it went almost unnoticed outside legal circles until Caniglia's appeal reached the Supreme Court. Caniglia appealed to the United States Supreme Court, which agreed to hear the case in November 2020. Oral argument was held on March 24, 2021. On May 17,
2021, the court ruled, unanimously, 9-0. Writing for the court, Justice Clarence Thomas held that neither the holding of Katie versus Dombrowski nor the reasoning behind it justified extending a community caretaking exception into the home. The opinion stressed something that sounds almost obvious once it's stated plainly, but had somehow gotten lost across two lower court rulings. The Fourth Amendment treats homes and vehicles very differently, and Katie itself had repeatedly emphasized that exact distinction. A car, sitting in a lot after an accident, is not a house. Extending a doctrine built for one to cover the other, the court found, wasn't a reasonable reading of the 1973 precedent. It was a doctrine being pulled somewhere it was never designed to go. Three justices wrote separately to make sure the ruling wasn't misunderstood as something broader than it was. Chief Justice Roberts, joined by Justice Breyer, noted that the decision did not prevent police from entering a home under genuine emergency circumstances, to stop an imminent suicide, for instance, or to help someone who was injured. That's a different legal doctrine entirely, known as exigent circumstances, and nothing in the Caniglia ruling touched it. Justice Kavanaugh's concurrence made a related point, and specifically mentioned elderly people who might have fallen and lost contact with others as a scenario where warrantless entry would remain lawful under existing law. He wrote that officers responding to a call about someone who hadn't been heard from and who might be injured or in danger inside their own home still had every legal ability to go in and check. That authority came from an entirely separate line of cases than the one the court was rejecting that day. The ruling that unanimously sided with Caniglia was narrow by design. It didn't strip police of the ability to respond to a real emergency. It stripped them of a doctrine that let them treat a wellness check with no emergency in progress as license to search a home and seize property without asking a judge first. That distinction between a genuine emergency and a caretaking function invoked after the emergency, if there ever was one, had already passed, became the entire substance of what the court decided. The Supreme Court's ruling didn't resolve how much, if anything, Caniglia was owed in damages. It vacated the First Circuit's decision and sent the case back down for further proceedings, meaning the constitutional question was settled, but the financial consequences of the violation still had to be worked out separately. Rather than go to trial on that question, the city of Cranston settled with Caniglia in April 2022, paying him and his attorneys close to $250,000 in damages and legal fees. The case had run for nearly 7 years, from the night of the original argument in his dining room to the final settlement filing. Long enough that the Caniglias had been married more than 2 additional decades by the time it concluded, having already spent over 20 years together before the argument that started the whole process. What makes Caniglia's case land differently than a traffic stop or a car search is the setting it happened in. He wasn't pulled over. He wasn't stopped on the street. He was in his own home, and then he wasn't even home. He was at a hospital, cooperating with the exact process police had asked of him when officers entered his house in his absence and removed his property. There was no accusation of a crime anywhere in this sequence. No charge was ever filed. The entire justification for entering that house rested on a doctrine that, until the First Circuit's 2020
ruling, had never applied to a home at all. It's worth being precise about what the Supreme Court actually decided, because the ruling is narrower than it might sound at first. The court did not rule on whether Caniglia's agreement to go to the hospital was truly voluntary. In his own court filings, he described it as something closer to coerced, saying he felt he had no real option to refuse. That question, whatever its merits, was never the one in front of the justices, and this channel isn't in a position to resolve it either. It remains an unadjudicated claim, not a settled fact. The case that reached the Supreme Court was about the search and seizure that happened afterward, inside his home, while he was gone. The court's unanimous opinion is about that narrow question and nothing more: whether community caretaking, a doctrine born out of a 1973 car case, could justify a warrantless entry into a house. The answer, from all 9 justices, was no. That distinction matters for understanding what actually changed and what didn't. The ruling doesn't touch a case where police have a real, present reason to believe someone inside a home is in danger. The Kavanaugh and Roberts concurrences went out of their way to say so explicitly, and the doctrine of exigent circumstances, untouched by this case, still allows officers to enter a home without a warrant when someone's life may genuinely be at risk in that moment. What the ruling ended was something more specific and, in its own way, more common. Police entering a home under a broad, non-emergency justification, a caretaking function not tied to any immediate danger, because a lower court had decided that label was flexible enough to cover more than a parked car. For 6 years, Edward Caniglia's case worked its way through the federal court system, carrying a straightforward question that had never been definitively settled at the highest level. Does the government need a warrant to search someone's house and take their property when there is no crime, no arrest, and no emergency in progress at the moment officers walk in? 2 lower courts said the community caretaking exception meant the answer could be no. The Supreme Court unanimously said the answer is yes. A warrant is required, and a doctrine invented for a car in 1973 wasn't going to be the workaround. The 7 years between that August morning in 2015 and the settlement filed in April 2022 track almost exactly the length of time it can take a single constitutional question to move from a private argument in a dining room to a unanimous ruling from the nation's highest court. At every stage along the way, the case could have stalled or gone the other way. The district court sided with the police on the core issue. The First Circuit affirmed that. It was only at the Supreme Court, after 2 lower courts had already accepted the department's reasoning, that all 9 justices agreed the community caretaking doctrine had been pulled somewhere it was never meant to go. Thomas W. Lyons III, Caniglia's attorney throughout the case, would later describe the ruling as confirming something that should have been self-evident from the start, that a home is not a car, and the Fourth Amendment has never treated the two the same way. For Edward and Kim Caniglia, the practical result of all of it was 2 firearms returned after a 3-month wait, a settlement reached 7 years after the argument that started everything, and a Supreme Court opinion that now sets the boundary for wellness checks nationwide, not just in Rhode Island, and not just for people who own guns. The ruling applies to any warrantless entry into a home justified purely on caretaking grounds, with no emergency and no crime in progress. What it doesn't change is what happened to the Caniglias themselves and the months it took to get there. The months without their property, the court order they were told they needed just to get it back, and the argument that, for one night in August 2015, briefly turned into something neither of them could have predicted. Caniglia's gun sat in police custody for more than 3 months after his release from the hospital, over a domestic argument that never produced a single criminal charge against him. It took a formal legal demand from his attorney to get them returned, and it took nearly 7 years and 9 Supreme Court votes to establish, on the record, that the department shouldn't
have taken them without a warrant in the first place. If you've had a wellness check called on you or on someone you love, and it went further than a conversation, that's worth telling us about in the comments. Cases like this one usually stay invisible for exactly the reason Caniglia's almost did. Nobody involved was ever charged with anything, which means, for most people, there was never a case to point to. A wellness check that ends with a hospital release and a property seizure doesn't generate an arrest record, doesn't generate a criminal docket number, and in most versions of this story, doesn't generate the kind of attorney involvement that turns a bad morning into a Supreme Court case. What made Caniglia's version different wasn't the severity of what happened to him relative to what happens in similar calls across the country every year. It was that he had the resources, the standing, and the persistence to push the question all the way to 9 justices and get an answer that now protects everyone else who might otherwise have had no path to one at all. I'm Marcus Whitfield. Thank you for listening to the Fourth Amendment Files.